Welcome to the Supreme Court Podcast. Is a company policy setting a lower retirement age for women discriminatory? This was discussed by the Supreme Court in the case Halagueña versus Philippine Airlines, G.R No. 243259. In the collective bargaining agreement between the Flight Attendants and Stewards Association of the Philippines and Philippine Airlines, the compulsory retirement age is 55 years old for female cabin attendants and 60 years old for males. A group of female flight attendants challenged this before the regional trial court, arguing that forcing them to retire earlier than their male counterparts is discriminatory. The RTC ruled in favor of the female flight attendants and nullified the questioned retirement age provision in the collective bargaining agreement. The Court of Appeals, however, reversed the RTC, ruling that the said provision is valid as mutually agreed upon by Philippine Airlines and the union. The CA also held that the early retirement for female flight attendants is based on, quote, the biological difference between male and female. The Supreme Court ruled in favor of the flight attendants and declared the provision void for discriminating against women. The provision violates the Constitution, which guarantees the fundamental equality of men and women before the law. It also violates the Labor Code, which prohibits an employer from discriminating against women employees solely based on sex. It is likewise contrary to the Magna Carta of Women, which prohibits gender-based distinction that restricts women's access to opportunities, benefits, or privileges. While employers and employees are free to agree on the terms and conditions of their collective bargaining agreement, these must not be contrary to law, good customs, public order, or public policy. In the present case, PAL was not able to provide a reasonable basis for differentiating the compulsory retirement age for female and male cabin attendants. The court held there is no proof that female cabin attendants between 55 and 59 years old do not have the necessary strength to open emergency doors or the agility to attend to passengers or the stamina to withstand grueling flight schedules as compared with their male counterparts. The court also stressed that the female flight attendants still had standing to question the provision, even if it was already incorporated in the CBA, as they had no choice but to accept the terms of the CBA in order to be hired. More importantly, the provision was initially assented to by their male-denominated union representatives who failed to protect the women's interests and even testified against them. To read the full text of this case, visit the Supreme Court website and search for the case Halagueña versus Philippine Airlines, G.R No. 243259.